So Chair Freiberg, would you like to move House File 2073 before the committee?
Sure, I will move that House File 2073 be recommended to be laid over for possible inclusion.
Okay, to your bill.
Just 1 second.
Oh, do you want to do, I guess, your amendments first?
Hold on, just one moment. Let me
Okay, I
pull
will.
up my notes here. Yes, this is the Secretary of State's administrative bill, and I'd like to move first the A1 amendment to get the bill in the shape I'd like.
Okay. To your amendment.
If we,
Just
maybe we could
technical?
just incorporate it, then we can
Or-
explain the bill as
Great.
amended.
Is there discussion on the amendment? Okay. Any opposition? We'll move to adoption of the amendment. All those in favor?
Aye.
Okay. The A1 is adopted.
Any opposed?
Or, it sounded pretty unanimous, so
Okay.
pardon. Any opposition to the A1?
Okay.
Okay.
Thank you.
The A1 is adopted. Thanks.
So it's my pleasure to carry the Office of the Secretary of State's administrative bill. As amended, this bill includes provisions to improve the way our elections function for voters across the state. It brings together feedback from election administrators and Minnesota voters. I think it probably makes sense for me to turn it over to Mr. Gehring to walk through the bill as amended.
Okay. Mr. Gehring.
Madam Chair, members, I'll just do a really high-level, quick walkthrough of the provisions of this bill, and then probably defer questions to the author, to the Secretary of State's office. But working from the document, House File 2073, as introduced, I'll start from there and then point out where amendments have made changes. Section 1 relates to the Election Day registration process and eliminates the requirement that operators of residential facilities prepare a list of names of employees, and instead allows residential facility employees to prove that they're employed by a facility, and that information is used to vouch for the residents of people who live in those facilities. Section 2 relates to proofs of residence that are permitted for students. This extends the law that provides additional proofs of residence for students to be used during the early voting period. Sections 3 and 4 on page 4 and 5 relate to the permanent absentee voter list. This changes the location of the box where voters can indicate they're interested in being on the permanent absentee voter list. Moving ahead to page 7 of the bill, section 5 comes from Representative Tapke's bill that the committee just heard, House File 2474, related to the designation of absentee voting locations and permitting municipalities to only designate a location for use during the early voting period. Moving ahead to page 8, sections 6 and 7 change terminology related to absentee ballot envelopes, so referring to signature envelopes instead of return envelopes as one example there. On page 9, section 8 permits off-reservation tribal lands to be used for pop-up absentee voting locations at the request of a federally recognized tribe. Section 9, the bottom of page 9, was changed by the A1 amendment. This includes some envelope terminology changes and also reflects language from Representative Tapke's bill. That is also true of sections 10 and 11. They all come from Representative Tapke's previous bill. Section 11 at the bottom of page 11, section 11 at the bottom of page 11 also comes from Representative Tapke's bill. Section 12 on page 12 looks like a more substantive change, but what this effectively is doing is requiring judicial officers, county attorneys, and county sheriff candidates to provide an email address when they file for office. And then this section also is requiring that for candidates who must prove residence in their district when filing for office, that if they use a utility bill to prove their residence, there are dates within which the utility bill must be current in order for that document to be a permissible proof of residence. Section 13, starting at the bottom of page 13 and running on to page 14, extends the proof of residence requirements to candidates who are filing for office using the absent candidates section of statute. So this is for candidates who will be out of the state for the entire filing period, or in certain circumstances for portions of a filing period that doesn't permit them to file in person while they're in the state. Section 14 extends the proof of residence requirements to candidates who are filing for certain local elected offices. Section 15 at the bottom of page 14 is extending the deadline for precinct boundary changes for election districts that are changed as a result of a municipal boundary adjustment, so that those districts must be changed at least 46 days before the election rather than 21 days prior. So that covers the entire absentee balloting period prior to the election. Section 16 on page 15 requires county auditors to develop a county elections chain of custody plan, and there's a number of details about what must be in the plan in this section. Local clerks, municipal clerks, school district clerks, and special district clerks are permitted to create local chain of custody plans as well, so long as they're at least meeting the requirements of the county chain of custody plan that would otherwise apply in that district. Section 17 at the bottom of page 15 and running ahead to section 18 on page 16 and 17 relate to the creation and use of election judge lists from political parties for the purpose of appointing election judges in precincts. And then moving ahead to page 18, section 19 of the bill adds new language to the election judge oath that includes a prohibition on election judges sharing information that is materially false or that would intentionally hinder, interfere with, or prevent a person from voting, registering to vote, or aiding another person in casting a ballot or registering to vote. Section 20 on page 18 eliminates an exemption that currently provides for untrained election judges to serve in precincts with fewer than 100 individuals who vote in that precinct. So in effect, with this change, all election judges would need to be trained regardless of the size of the precinct. Section 21 is the errors and omissions statute, and the amendment here is to provide a method for resolving allegations of an error or omission by mutual consent of the complaining candidate as well as the election administrator without going through a court proceeding. On page 20, section 22 of the bill relates to mail ballot jurisdictions. So this requires that in jurisdictions that conduct their elections entirely by mail, ballots must be mailed out at least 28 days prior to any election, as opposed to a 14-day mailing period prior to a regularly scheduled election and 30 days, between 14 and 30 days prior to other elections. So a blanket 28-day mailing calendar is established here for those jurisdictions. Section 23, which starts on page 21, but the substance is on page 22, eliminates a reference to a prohibition on candidates assisting a voter in marking their ballot in a voting booth. This conforms to a court decision that allows for candidates to provide assistance to a voter who requests it. Section 24 at the bottom of page 22 allows election judges who are currently required by law to initial ballots to initial either the front or back of a ballot as opposed to just the back of the ballot to certify that it's being used at the election. Section 25 allows or modifies the voter certificate that is signed by voters to attest to their eligibility to vote at an election to provide for their certification that they maintain residence at either the address or location shown on the registration. Section 26 on page 24, along with section 27, relate to canvassing of elections. Section 26 relates to canvassing of municipal elections, and section 27 relates to canvassing of school district elections. In both cases, there are amendments in the A1 that was adopted that eliminate some of the timing changes that you see here, but what remains is a requirement that the canvassing boards declare the candidates duly elected to receive the highest number of votes for the offices that are being canvassed. Section 28 relates to combined polling places in school district elections. This allows school districts to designate polling places that are not used by a municipality. It's sort of a jumble to explain here, but in jurisdictions where municipalities conduct elections by mail, school boards can still designate a combined polling place in locations even if the municipality doesn't use that same location for voting because they conduct their elections by mail. Section 29 on page 26 provides amendments to the law that that contains a process for dissolving towns in Cass, Itasca, and St. Louis counties. Among the changes is elimination of a requirement that in those counties, a town dissolution question be voted on by a separate ballot. So this could be with this change, towns could be dissolved in those counties by a single ballot, and also changes some deadlines related to filing a petition for dissolution. Section 30 on page 27 extends the deadline for county special elections to be declared. Section 31 provides changes related to incorporation or municipal elections in the case of an incorporation or consolidation of a local government, and requires that those elections happen on a set of uniform election dates that have been provided by law. Section 32 on page 28 relates to canvassing of hospital district board elections. Section 33 on page 29 transfers remaining balances in the voting equipment grant account established by law to the new voting operations technology and election resources account. And that voting equipment grant account is being repealed by section 34. And then additionally in the repealers, there's a repealer of section 209.06, which relates to the appointment of inspectors to examine and count ballots in an election contest. And Madam Chair, I think I'll turn it back to you.
Okay, thank you, Mr. Gehring. So this is the overview of the proposal that the authors presented before us. We're going to move to testimony, and then we will go back to consider the other amendments that have been submitted for this. So I have first Mr. Stahlberger.
Good afternoon again. For the record, Michael Stahlberger, Director of Property and Environmental Resources for Blue Earth County, representing MACO, the Association of County Officials. We're here to express our support for many of the provisions in House File 2073. We've worked with the Secretary of State's office on many of the provisions, and we look forward to continuing some of the conversations that will exist on some of those items. Some of the items that I'll bring your attention to that MACO strongly supports. The section, I believe it's 3, depending on the amendment level, of removing the permanent absentee ballot request option from the voter registration application. Permanent absentee ballot requests are increasing in their number. They bring a significant amount of administrative workload with them, and having that be part of either a separate process or only be available for voters who are already requesting a ballot as opposed to when they're trying to register will help us actually administer that more effectively. We also support the sections that are establishing a more effective process to appoint party-affiliated election judges. We do rely on those judges to serve in our polling places. They're a valuable resource in terms of providing party balance in our polling places. However, having a more well-documented and defined process will be helpful in that regard. We do have some continuing concern amongst our membership about the 14-day response window and whether or not that's too long of a window to make sure that we can get folks trained in time, but we look forward to continuing that conversation. We also strongly support Section 23. Section 23 is the section that creates a process for counties, candidates, and other individuals to correct ballot issues. That is something that we really hope to not have to use. We try our best to not have issues on the ballot, but folks probably remember the 2024 election and the numerous ballot issues that were identified. This provision, worked in part with the Secretary's office and the county attorney's groups, will allow us to make some of those very technical administrative changes much more quickly so that voters are less impacted and we can keep our election processes moving forward. Some of the provisions that we would bring attention to that we would for sure want to continue conversation on. Section 2, the student housing lists. Those are a valuable resource for registering students who live in on-campus housing or near colleges and universities in the state of Minnesota. However, we only have a 2-day window right now from when we receive those lists to when we'll be required to use them under the proposal. And we want to make sure we have enough time to validate the information so that it's correct and accurate before we use it. I already mentioned some changes regarding when permanent absentee ballots can be requested. Section 4 makes that a requirement as part of the absentee ballot application. That is a step in the right direction, as already mentioned. However, counties would continue to prefer that to be a standalone application. primarily so that we can fully educate the voter on what they're doing with that request, but also so that we have a separate record and a signature from that voter so that we can validate their return ballots in instances when we don't have information to verify their driver's license or last four of their social security number. We also really appreciate the attention towards establishing a chain of custody plan and having that be required for counties and cities and towns if they would so elect. However, we want to acknowledge that that's a significant workload addition to county elections administrators, and so we'd want to continue the conversation with the Secretary's office to ensure some consistency statewide with templates, assistance processes, ways that we can make sure that we've got a really good and robust and workable chain of custody plan, not just something that checks boxes. With that, I'll actually close my testimony to save some time. I'll remain for questions. We really do appreciate the Secretary's ongoing willingness to partner with MACO and counties to make sure these changes are appropriate and administrable. But I'll stick around for any questions that the committee may have or that may arise. Thank you.
Thank you, Mr. Stahlberger. So I don't have any more testifiers who've signed up, but are there members of the public who would like to testify on behalf or in opposition to the bill? Okay, so seeing none, we will move to amendments to House File 2073 as amended. I have first on my list the A7, which I believe Chair Quam, are you offering that? Chair Quam?
Thank you. Basically, there needs to be some clarification in this area because there are some concerns of in the underlying statute with interference with religious rights, with the fact that the judge isn't provided a copy of the statute. And so this would just delete line 11 of page 18 and insert in accordance with Minnesota statute section 211B.075 and insert in the performance of my duties as an election judge. So that also clarifies that the oath is for the duties of the election judge as opposed to a little bit of broader of a definition.
Thank you. Chair Freiberg.
Thank you. This is just deleting a reference that's in the oath taken by election judges. As far as I know, the statute would still apply to all the relevant people, so I'm okay accepting this amendment and would encourage a yes vote.
Any other member discussion? Okay. All in favor, say aye.
Aye.
Any opposed? Okay, the A7 is adopted. Okay, so we'll move on to the A2 next, which is also Chair Quam's.
Thank you, Madam Chair. Basically, this is just adding that the effectiveness of this section is July 1, 2025, and then that any off-reservation tribal lands that exist that date. So when ones are added, that would require the legislature to look and address. And that would also allow us to see how things are going if we need to improve or clarify any language at that point.
Chair Freiberg.
I'm willing to work on this one, but I'm not really comfortable accepting it today. I'm not, just full disclosure, I'm not totally familiar with the process of designating new off-reservation lands. And I don't want to foreclose the possibility that a newer off-reservation land might be a good place for a new polling location. But I'm certainly willing to work with Chair Quam. The bill is just being laid over, so, but I don't think I can accept this one as it is at the moment. I believe the Secretary of State's office was also trying to reach out to MIAC just to get their input on this one as well. And I think that'd be an important voice to have at the table.
Chair Quam.
Madam Chair, I would then pull this back for future discussion. Thank you.
Okay, thank you. So the A2 is withdrawn. Next, I have the A3, also Chair Qualms.
that's-
Okay. Vice Chair Altendorf.
Thank you, Madam Chair and Chair Freiberg. A3 is very simple. Actually, it's going to simulate the law that we already have, that no polling place shall be designated in any place where intoxicating liquors are served. And so this is the same in the sense that with the new marijuana laws coming out, that we also will not have polling places in any tribal areas that marijuana is being sold.
Chair Freiberg.
Thank you, Vice Chair Altendorf. I'm open to this idea as it's as you described it, but I think actually it should be broader. I'm reluctant to apply it only to tribal lands, but as you noted, Vice Chair Altendorf, there is a statute that prohibits any sort of alcohol from being present at a polling place. I'd be fine expanding that to include cannabis, but kind of the way, and you know, if this comes back, I'd be fine accepting that. But the way I was just double checking the cross reference. As I see it, it's part of a section that's amending 203B.08, and the provision you mentioned about prohibiting alcohol is 204C.06. So like, I don't think this should apply only to tribal lands. If it were, I think I'd want to consult with MIAC again, but if it's broader, if it's just a general prohibition on cannabis, similar to the type we already have on alcohol, I'd be okay accepting that. So I don't know if you'd amenable to pulling it back and we can work on language on it.
Vice Chair, Nicole Freeman, did you want to say anything? No, okay. All right, Vice Chair Altendorf.
Thank you, Madam Chair. And is that something then that we can do an oral amendment on? That it just, we're just looking so that it's the same.
Chair Freiberg.
I guess.
I guess, Mr. Gehring, is this something that is doable or probably cleaner if we take time to draft it? Yeah.
Madam Chair, I think I would recommend probably writing up that in the new section of statute, just because this is a sentence that is going into a specific subdivision of absentee voting law. So to put it in the correct section of statute would probably require a written amendment.
Okay.
Yeah, I do.
Yeah, Chair Freiberg.
Yeah, I do offer my commitment to including that as long as it's included in the right section and not specifically dealing with tribes, I guess.
Yeah, I guess, Chair Quam.
Thank you, Madam Chair. And I would think this could end up being a very simple one where in law it says alcohol. We can add the appropriate language for, I would think we could even do something that it doesn't just say marijuana, but in anything that would inhibit or, affect your judgment and et cetera. So I think it's a little bit of language. It could be a simple amendment, and I think our people are willing to come together to make it so.
Chair Freiberg, yeah.
Thank you, Chair Quam. I do agree it would be pretty simple. I suspect Mr. Gehring could do it in his sleep, but if he were at his desk and had the proper statute, it's just I do know that the amendment as draft, it wouldn't be as simple as, it would probably be more complicated actually amending the amendment just because it's a separate statute of law. But I pulled up the actual statute. It's 204C.06. I imagine, we'd probably want to get approval, but it says, that subdivision 7 of that statute says use of intoxicating liquor, prohibition, penalty. During the time an election is being held, it is a misdemeanor to bring intoxicating liquor or 3.2% malt liquor into a polling place, to drink intoxicating liquor or 3.2% malt liquor in a polling place, or to be intoxicated in a polling place. I imagine a new amendment that references that statute, but there's probably specific language we want to use regarding cannabis and cannabinoids and hemp and all that, and he'd probably want to consult with the health researcher, so I think it's probably better to wait a little bit. until, like I said, this is being laid over, but you do have my commitment that I'm okay with something along those lines.
Okay.
And maybe Chair Quam can bring edibles to that discussion too.
That's right. Thank you, Chair.
Let me-
Yeah, I think that sounds good. Vice Chair Altendorf.
Thank you, Madam Chair. Yeah, no, I didn't mean to complicate this, and this isn't funny, really. And I'm certainly not meaning to target the tribes. It's just that there is so much going on right now with the Office of Cannabis Management that the public is not aware of what's going on with the licensing, and do think that this is an important part of the discussion that needs to be had. Thank you.
I agree with that, Vice Chair Altendorf. Does that mean you're withdrawing the amendment or for purposes of?
Yeah, absolutely. Yeah, I will withdraw it, and thank you, and we'll work on it. Thank you.
Great. The
Thank you.
A3 is withdrawn. Next, I have the A4, and are we going down the line, or is it? Oh, okay, all right. Representative Gordon.
Thank you, Madam Chair. So this amendment would do two things. It would take the underlying bill, which says 24 months on that the list that the election judges have from the parties that could be used is 24 months old, would change it to 26, just because caucuses sometimes could be 25 months. So it's just taking into account that variation of the caucus dates. And then it also would delete the language that requires political parties to submit the date they recruited the potential election judge, just because that's not how parties actually operate, and it would lead to election administrators arbitrarily rejecting otherwise qualified election judges.
Chair Freiberg.
Thank you. I'm okay with the language on line 1.2, and I'd actually be fine if you wanted to divide the amendment and do that. I do have, I've checked with the Secretary of State, extending the period for election judges to indicate interest from 24 to 26 months is certainly doable. The other two things, first, the amendment eliminates the requirement that potential election judges lists contain the date when they were interested in serving. Like, my understanding from speaking with Nicole Freeman about this is that, it's helpful, especially if there is going to be this requirement that they serve for 24 or 26 months, that the date they expressed their interest, just as to start counting from. If you wanted to change it to make it more general, like so that it's just the month and the year rather than the date, I'm open to considering that, but I'm not sure how administrable that provision is. And then the other thing it does is it changes the requirement that election judges provide both their email address and their phone number to a requirement that they provide only one. My understanding is that jurisdictions kind of need every method possible. Like, it's hard enough to recruit election judges, so having both options available makes it a lot easier for them to keep in touch with these people to find out if they're willing to continue to serve. So, I mean, if you were amenable to it, I think this amendment could be divided between line 1.2 and 1.3, and I'd certainly be happy to accept the first part of it.
Great. Rep. Gordon.
Thank you, Madam Chair. Let's just pull it back and keep working on it. We're laying it over anyway, so let's just put some more thought into it and take it from there. Thank you. Thank you.
Okay, the A4 is withdrawn. I have next the A5 and to Representative Davis.
Thank you, Madam Chair. And Chair Freiberg, I appreciate that this bill does recognize that election officials need to get their lists a little sooner for primary elections and whatnot. But the deadline for getting the lists in, it makes it pretty unworkable for the MNGOP with caucuses. It's caucus season. And so this amendment, it just changes it to a preliminary list so they can get going on it. And then provides that we can put in a final list of names that we would pick up from caucuses, because a lot of times we can't get information processed from those caucuses until after that March 15th deadline. So it would just make that list a preliminary list, and then we can also turn in a secondary list after that deadline. Does that make sense?
Chair Freiberg.
Thank you, Madam Chair. Thank you, Representative Davis. It makes sense. I'm not sure how administrable the solution is. Like, having two lists seems like it could be difficult too. I'm certainly willing to work with you. I don't know exactly what situation you're describing at GOP caucuses. I haven't been to a GOP caucus.
Oh.
I think it would be an interesting field trip. Maybe I could put on some Groucho Marx glasses sometime and join you for your caucuses, because I don't know that anybody would be super excited to see me there otherwise. So I think disguise would be very important. But joking aside, I am. This is something I'm happy to work on. I'm just not sure I did check in. I heard having 2 lists might be difficult. It would be hard to cross-check whether people have been contacted off of one list but not the other. But I certainly, we do have similar data entry issues, I do know, in DFL caucuses as well, and certainly want to make something that's workable off of those lists.
Chair Quam. Representative Davis.
Thank you, Madam Chair, and I can assure you I've never been to a DFL caucus. But I'm guessing you guys sign up election judges just like we do.
Yes.
And some of those election judges are probably going to be expecting to be used that following election, and so that's what it addresses. Would Nicole Freeman want to speak to this? I mean, from my point of view, it doesn't seem like it'd be that hard, but I would love to hear from you.
Ms. Freeman.
Thank you, thank you, Chair, and Representative Davis. I also say that Mr. Stahlberger might have thoughts on this too, as they're the ones that are working with this list on the ground. But yeah, in our conversation, it was the confusion bit did come up around, how are you sure that you're exhausting? So then you need to exhaust both lists. And if you're hiring for your absentee ballot board for the primary, that ballot board would start like a week after June 15th, depending on, where exactly the second Tuesday in August falls. But being able to I think there's a question of like, if you have to exhaust the list before you can move on to hiring other people, if you're waiting for a list, so you could hire people from that first list and then you'd pause until June 15th. I don't think this is the intent, but I think this is sort of one of the questions, right? Then do you have to pause until June 15th and then contact that list and then exhaust that list before you can go on to look to hire and train folks for the ballot board? So I think we can definitely keep talking about what is a more appropriate deadline. Like, can we bump the deadline up from May, and what is a workable timeline there? Yeah.
Representative Davis.
Yeah, thank you, Madam Chair. And I was just going to suggest, and maybe it would be a better idea just to stick with the original date for that secondary list. That's already in statute.
Ms. Freeman.
Thank you, Madam Chair. I think we still run into the same issue of you're starting the process in March, you're starting to train people, but then there's sort of the open question of statute says you need to exhaust the list, and even in our amended language, it talks about needing to exhaust the party list before you can move on to hiring other folks. And so I think there would still be the question of, okay, so then you are getting the list on a secondary list on May 15th. But that still puts, so then they have to contact that list. I think our timeline has like a 14-day window. So then again, you're like into June before a county could reach out to, or a municipality that has a ballot board could reach out to additional folks who have, opted in through other means. And so I think that's, I think in an ideal world, we would have one list, and parties would continue to be able to send supplemental lists to counties for consideration. I know counties appreciate those additional lists, and I know our office has pointed counties who need judges of one political party or another back to the parties and their local party units to engage and try to drum up some more names. So I think that additions to the list could continue, but from a formal standpoint of needing to exhaust this list before moving on to other folks who might sign up from other means, I think it's really important for it to be a list that's transmitted at one time.
Representative Davis.
Yeah, thank you, Madam Chair. Yeah, we're just trying to make it easier for counties and to make sure that, you know, election judges or people who want to be an election judge, they're not being left out when they sign up during that time. So if you could work with us on something that's amenable, we'd really appreciate it. So,
Yep.
and with that, I can draw this amendment.
Okay, the A5 is withdrawn. Yes, apologies, Chair Quam.
Thank you, Madam Chair. And Chair Freiberg, I actually attended both caucuses when I was 17, checking out, you know, the two parties and et cetera. But the whole issue is in the language currently in the bill. It pushes up to where we've had caucuses in March. And so you really, that gets the grassroots involved. That's where people sign up at the caucuses to be election judges. And you need to have enough time. So I like the idea that there's discussion about trying to find a better timeframe. And as long as it gives us enough time to actually take care of that after a caucus, then I'm, you know, open and willing to work with you. I just think the current form of the bill is problematic some years. Thank you, Madam Chair.
Chair Freiberg, did you want to respond?
Yeah, give me a second here.
Okay, I think while you wait, then maybe I'll recognize Representative Coulter.
Yeah, just real quickly, as we're debating May versus March, you know, I haven't looked at a calendar all that recently, but last time I recalled, there's another month in between those. So one possible compromise might be to say April 15th, which would be, I mean, yeah, well, you know, hopefully you're doing your taxes before April 15th anyway, right, folks? But that would be probably more time, I think probably enough time in between caucuses and before ballot boards start their work. So just as a sort of split the baby kind of suggestion here, something to think about.
Thank you. Okay, Chair Freiberg.
Yeah. We're just brainstorming here. Representative Davis, you know, if, you know, we do want to address this issue, which, you know, one possibility would be to amend the language in the underlying bill. So right now on line 15.31, it references March 1st. You know, that could be changed to April 1st. On line 16.19, it references March 15th. That could be changed to April 15th.
Representative Davis.
Or we could keep talking about this, but if, you know,
Yeah.
just as a,
Yeah.
if you wanted kind of as a good faith gesture, we could make that as an oral amendment right now.
Let's just keep working on this. And I'm going to stick with my withdrawal, but I know you're going to be a man of your word on this. So
Okay.
we'll work on it. And I'm glad that you came up with the same idea that Representative Coulter did.
Yeah.
So, thank you.
Great minds think alike.
I didn't even hear what he said. I was too busy trying to find the right line numbers. So I'm glad to hear that he agrees.
Great. So the A5 is withdrawn. It looks like we have a doubleheader, Representative Davis to the A6.
Yeah, again, something I like about this is clarifying that there's at least a little bit of balance with major political parties on the ballot boards. I guess I would like more clarifying language, but as far as exhausting the party list, I would like it to just go a little bit further as far as exhausting those lists. And so this amendment just changes, instead of just making one phone call, you make 2 phone calls, and then response time of 30 days instead of 14 days for hearing back on those phone calls.
Chair Freiberg.
Yeah, this is another one where I'd like to keep working with you. I do know, and I suspect like Mr. Stahlberger might have comments here, but my understanding is, you know, extending the wait list to, they have trouble sometimes contacting the election judges, and the requirement to exhaust the list can be challenging. So, you know, I know waiting 30 days before being able to move on to other interested election judges might not allow them to be ready for absentee voting, which begins by mid-June. My understanding was even the 14 days that are in the bill right now might be tough for some of them. They might be open to changing the once to twice, but I'd kind of want to run that by a few people first. But that's kind of, I don't know if Mr. Stahlberger, how closely,
Mr. Stahlberger is still here, so,
okay.
Mr. Stahlberger, did you hear the question?
I did. Thank you, Mike Stolberger, Mako, just for the record. Yes, when we surveyed our members about this change, we reached out to them, and the 14 days was kind of seen as the extent of a workable time frame for us. Extending that to 30 days would add a lot of delay in us actually moving forward with getting those judges who have expressed interest into our training queues, making sure that they can meet all the training requirements, getting that information passed along to our cities and towns so that they can get them appointed to their local precincts as well. So there's a fair amount of work that occurs after we've reviewed the lists, offered interest, allowed those election judges to offer their interest, to get signed up and all of that. And so the switch to 30 days would be problematic. Going between 1 and 2, that might be something that we could continue the conversation on. One of the biggest issues there that I'll point out is that oftentimes folks sign up for that list because they're really excited and energized at the caucus. But once they start hearing about training requirements and whatnot, they're no longer interested. And so if we have to reach out to them twice, we're going to make some of those folks disgruntled. But maybe there's a way to document that first denial or something like that and say that's exhausted it. So in summary, I guess the 30 days would be less desirable, much harder for us to administer. The 1 versus 2 reach outs is something that we could maybe continue the conversation on.
Great, thank you. Representative Davis.
Thank you, Madam Chair. Thank you, Mr. Stahlberger. That actually makes a lot of sense. And so I will continue to think about this once to twice, 1 to 2 phone calls. But with that, I appreciate his testimony. I'm going to withdraw this amendment as well.
Okay, the A6 is withdrawn. Next, we have the A8, Representative Altendorf.
Thank you, Madam Chair and Chair Freiberg. So thank you for this, what we're doing here. I think, it makes a lot of sense. We're looking for an out-of-court remedy when there is a problem with a ballot, with an error happens, which happened a few times this last election, most notably to Representative Bennett, where she was listed as a Democrat until she had people complaining, constituents saying, when did you switch parties? And then they found that out. So previously, it would take a court order and to change that. And what you're doing is making it so that the 2 candidates can basically agree and that would be changed. But what my amendment does is it allows the option for the candidate to still go to court if they feel like they were harmed. So it's very simple. It just leaves that as an option, but I would think most cases where there was a mistake that it could be done by agreement by the candidates.
Chair Freiberg.
Yeah, I'm certainly willing to work on this provision. I do have I guess the one concern I might have is that it sounds like things in the situation involving Representative Bennett were handled amicably, which is great. But, if supposing her opponent had kind of become difficult and didn't want to agree, then it would be, they came up with a serviceable solution, it seems like, but then Representative Bennett would be required to go to court. I don't know, Ms. Nicole Freeman may have a comment on this.
Ms. Freeman.
Yeah, thank you, Madam Chair. I'm a Representative Altendorf. So why we inserted this into the requirement for a candidate who does not, or a party in this who does not prevail, as well as someone who the judge rules that their arguments are not made in good faith. It would just be court costs. And so the goal there was to incentivize candidates to come to that out-of-court agreement. So in the situation like Representative or Chair Freiberg noted, say that there's a really crystal clear solution, which I think a lot of these are. They're either they're often typos, right? And so this was like a clear switch of party. And so what happened this year is that because it had to go to court, it took almost 2 weeks, over a week for sure, for that resolution to happen, just because of the different, the court process. And so our goal in putting this in there is to give us a little bit of incentive to nudge candidates that are, that might be a little reluctant to agree to a solution. The only time that they would need to pay any court costs, they're not paying attorney's fees, but it would just be the filing costs that they potentially could be required to pay, would be if they were the losing party, as well as their position was found to be not substantively justified or made in good faith. And so it would be limited circumstances, but would allow counties to point to this to say, please come along and agree. And so that's why that was in there. But if there's another issue with the provisions, I'm happy to continue to work with you too.
Great. Representative Coulter.
Yeah, just quickly, thank you, Madam Chair. I just wanted to point folks to, it is line 18.26 in the original bill. Just to clarify, because I think maybe there may have been some confusion on this, that this does not eliminate folks' ability to seek remedy in court. The new language does not eliminate that ability. It just says that basically, if they do go that route, like Ms. Freeman was saying, if they do go that route, there may be some option for the county to recover some court costs there. So folks would still have the ability to seek a remedy in court if they're not able to come to this agreement. Just wanted to clarify that a little bit. Thank you.
Ms. Freeman, is that accurate?
Yes.
Representative Altendorf.
Okay, thank you, Madam Chair. And again, so yeah, I'm not disagreeing with what you're doing here, because, so for example, in my district, I was listed on the ballot as Steve Jacob, and that had to go through court. So that again would be another example where the parties would have easily agreed and it would have been done. What my amendment does is just allows the option. So I'm not taking away. I think probably 99% of the cases, the candidates would agree, that there was a mistake made.
Okay. Chair Freiberg.
Are you accepting the amendment? Or no?
I don't think I'd like to keep working on it. I hate to sound like a broken record. I just, it's good to have flexibility in committee, but sometimes drafting these kind of on the fly in a public setting is less than ideal, because it can make mistakes. Although the bill is just being laid over too. I wouldn't bring it back until we've had discussion about these issues.
Yeah, sounds like that's a plan. And I guess since we're all sharing stories, in my first race, my GOP opponent passed away, and so they sent out the wrong ballots with the wrong candidate. But that, because it wasn't a primary, having to go to court actually cut down the time that people could vote. And so I appreciate the Secretary of State trying to find this remedy. Representative Altendorf.
Madam Chair, yeah, I will, thank you, Chair Freiberg, and I will withdraw the amendment. And again, yeah, I think it's very simple. It's something we can work on. Thank you.
Great. The A8 is withdrawn. And then looks like we have the A9, Representative Roach. Representative Roach. Are you presenting the A9? To your amendment.
I think so, yeah, that's a good one for Stolberger,
Yeah, I move to amend House File 2073. It's the A9 amendment.
Do you want to describe the amendment for us?
Okay. Yeah, it renumbers the sections in sequence and correct the internal references, pages, or amend the title accordingly.
Representative Roach, would you like a nonpartisan staff to go through the amendment or what it is? Okay. Mr. Gehring?
Madam Chair and committee members, this amendment, in addition to what Representative Roach described, would delete the sections of the bill that relate to canvassing of returns in municipal elections, hospital district elections, as well as school district elections. So this is the language currently in the bill that amends the timing for having canvassing board meetings, then also requiring the canvassing board to declare the candidate who duly elected to receive the highest number of votes for the office being canvassed.
Thank you. Chair Freiberg?
So, thank you. In the author's amendment, we did alter the timeline for local jurisdictions to conduct their canvassing board meetings and adjust it to the range of 3 to 14 days. I know local jurisdictions were asking for flexibility on it so they could schedule a canvassing board meeting at the time when counties have the materials ready, hopefully at a time that overlaps with the regularly scheduled meeting. I was thinking this might be a good one for Mr. Stahlberger to comment on if he's still available.
Mr. Stahlberger, did you hear the question?
I did hear the question. Thank you. Michael Stolberger, representing Mako. The change here, the way that we understand the change is that it does provide that flexibility to allow our cities, our towns, our school districts to canvass when it works a little bit better for them, but it still gives us a wide enough range to allow counties to make sure that they have all the records prepared and that they've done their audits of those returns before they release them to the cities and the towns. So leaving it as a change between the 3rd and 14th day would be preferable from the county administrator perspective so that we can try to find that magic date that works well to have the records ready and reviewed by the county, but still have them align with a city council meeting or a school board meeting so that they can canvass their portion of the returns.
Chair Freiberg, any other thoughts?
Yeah, I guess I'm not, at this point, I'd prefer to keep the language in there. I mean, if there's things we can tweak to do the timeline, you know, it's not totally the hill I'll die on, but I do think it provides some flexibility to local governments for their canvassing boards. But certainly happy to work with Representative Roach to see if there's ways we can address his concerns with the timelines in the bill.
Okay. Representative Roach? Do you want to close?
Yeah, since it's being laid over, I'll withdraw the amendment.
Okay, thank you.
Okay. The A9 has been withdrawn. Okay, so it looks like we've exhausted the list of amendments. I don't know, Rep. Freiberg, if you want to close, or if there are other members who want to, yeah, add comments on the bill as a whole.
I guess I'm not seeing anyone raise their hand to the bill. Oh, Representative McDonald.
Or Representative
Davis.
McDonald.
Yeah, Madam Chair, Representative Freiberg, just curious, when do you plan to pass out the treats you brought?
Oh, you're welcome to have one right now. They're right there at the end. I made sure to put them on the GOP side. I figured I needed to be nicer to you guys.
Sounds like that's on Rep. Roach. Representative McDonald. Okay.
All right.
Anybody else? Oh, no? Lead Quam or Chair Quam?
Madam Chair, I believe one of the chairs needs to lay this over.
Yeah.
Okay.
Well,
What, did you want to close? I mean,
sure.
yeah.
No, thank you, Madam Chair. I just wanted to make sure everyone had an opportunity to ask any questions if they had any. So I appreciate your consideration. I do look forward to working with you on the amendments you brought. I think they raise a lot of interesting points, and I'm sure this isn't the final stop for it. So look forward to working with you to make this bill even better. So thank you for your consideration. And with that, I will renew the motion that House File, what was it?
2073.
2073, as amended, be laid over for possible inclusion.
So moved.